Welcome to our deep dive on maximizing immigration chances through multiple family petitions. Today, we'll explore how a single beneficiary can be listed on more than one immigrant visa petition, why families use this tactic, and how to avoid common pitfalls. First, we'll define petition stacking. Then, we'll compare eligibility differences for lawful permanent residents and citizens. Next, we'll study the strategy behind filing a second petition, and we'll finish with key warnings and tips to protect your priority date. Let's begin. Here's the roadmap for our session. First, we'll define petition stacking. Second, we'll cover eligibility differences between lawful permanent residents and U.S. citizens. Third, we'll explain how a second petition can create a faster path. Afterward, we'll look at wait times across categories and discuss priority dates. Then, we'll walk through a step-by-step strategy, answer quizzes to reinforce learning, and finally wrap up with key takeaways and an important disclaimer. Let's move on to the core concept. Petition stacking refers to a situation where one beneficiary has more than one family-based immigrant visa petition filed on their behalf. This creates parallel paths toward permanent residency. Although filing multiple petitions doesn't make the government process itself move faster, it can provide options when a quicker category becomes available. In practice, families often start with a slower category and later add a faster one once a more eligible petitioner is available, such as after naturalization. With that concept in place, let's transition to eligibility basics. Eligibility is foundational. Lawful permanent residents can generally petition only for their spouses and unmarried children. They cannot petition for parents or siblings. By contrast, U.S. citizens can file for immediate relatives, including parents, spouses, and unmarried children under 21, as well as preference categories like married children, adult children, and siblings. Consequently, if your goal is to sponsor parents or siblings, it is strategic to naturalize first. Moreover, filing as an LPR in a slow category can start a very long waiting period. With these rules established, let's examine how a second petition can accelerate things. This flowchart guides the decision on who should file first. It starts by distinguishing whether the petitioner is a lawful permanent resident or a U.S. citizen. It then branches by the beneficiary's relationship. Immediate relatives like spouses and children under 21 usually qualify for the fastest processing when the petitioner is a U.S. citizen. The chart also highlights sibling petitions as very slow under category F4. If a sibling initially files, but a parent later becomes a U.S. citizen and petitions, the parent's petition typically outpaces the sibling route. The diagram includes decision points on whether naturalization is possible soon. If yes, it suggests waiting to file as a U.S. citizen for faster categories. If not, it recommends filing now to secure a priority date while planning for a potentially faster petition in the future. Now, let's quantify category wait times. This table outlines common family-based categories and their relative speeds. Immediate relatives of U.S. citizens are generally the fastest because they are not subject to annual numerical limits. Categories like F1, F2A, F2B, and F3 have annual caps and backlogs that vary by country of chargeability. The F4 sibling category is often the slowest, sometimes spanning 20 to 40 years. With this context, let's discuss the strategy behind filing a second petition to move into a faster category when possible. Here's the common strategy. A sibling may file an F4 petition to secure a place in line, but F4 is extremely slow. Later, if a parent immigrates or naturalizes, that parent can file a new petition for the same beneficiary. Parent-based categories, especially when the petitioner is a U.S. citizen, generally move much faster than F4. While filing multiple petitions does not accelerate government processing by itself, it positions the beneficiary in more than one queue. When a faster category becomes current, that path moves forward. Now let's compare the sibling route with parent-based options directly. On the left, the F4 category allows a U.S. citizen to petition a sibling. This path is often very slow, sometimes 20 to 40 years, and constrained by annual caps and country-specific backlogs. It can be useful to secure a place in line early. On the right, parent-based categories are generally faster. If the parent is a U.S. citizen and the beneficiary qualifies as an immediate relative, there is no annual cap, which can significantly speed up the process. Even when not immediate relatives, many parent-filed preference categories move more quickly than F4. In practice, once a parent can file, that path often overtakes the sibling route. Next, let's visualize a typical timeline. This timeline illustrates how petition stacking can unfold. In year 0, a U.S. citizen sibling files an F4 petition. Around year 3, the parent becomes a lawful permanent resident, and by year 5, the parent naturalizes as a U.S. citizen. Immediately after naturalization, the parent files a new, faster petition, potentially as an immediate relative, F1, or F3 depending on the beneficiary's marital status and age. Between years 6 and 8, the parent-based petition becomes current and moves forward. Throughout, the earlier F4 priority date is maintained in records, which can sometimes be advantageous if category conversion rules allow. However, only the category with current visa availability actually advances. With the timeline clear, let's walk through practical steps. To execute a multi-petition plan, start by mapping relationships and immigration statuses. Next, identify the likely category and consult the visa bulletin to estimate wait times. If only a slow option exists, such as F4, consider filing to secure a priority date. Meanwhile, plan for the naturalization of potential petitioners who can open faster categories. Once a faster petitioner becomes eligible, file a second petition promptly. Meticulous record keeping is essential. Retain receipts, approval notices, and priority date documentation. When a faster category becomes current, advance on that path, but preserve earlier petitions in your records. Finally, if category changes occur, consult competent counsel about the possibility of retaining priority dates. Now let's focus on protecting priority dates. Priority dates are the lifeblood of family-based immigration timelines. Protect them by keeping every I-130 receipt and approval notice. Document status upgrades, such as a petitioner naturalizing from lawful permanent resident to U.S. citizen. Learn the rules regarding priority date retention when categories convert or when a new petition is filed. In limited scenarios, earlier priority dates can offer advantages. Remember, although you can have multiple petitions, only one category with current visa availability will proceed at any given time. With these safeguards in mind, let's test your understanding with a quick quiz. Question: true or false? Filing multiple petitions automatically makes your case get processed faster by the government. Option A, true. Option B, false. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is false. Filing multiple petitions does not automatically accelerate government processing. Instead, it positions you in multiple queues, allowing you to proceed when one category becomes current. Now let's continue with a second question. Question: which path is often the slowest for family immigration? Option A, immediate relatives of U.S. citizens. Option B, F2A, lawful permanent resident to spouse or unmarried child under 21. Option C, F4, U.S. citizen to sibling. Option D, F1, U.S. citizen to unmarried adult child. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is F4, the U.S. citizen to sibling category. It is commonly the slowest, sometimes requiring 20 to 40 years depending on the country of chargeability. With that confirmed, let's consolidate our main lessons. Here are the key takeaways. First, a single beneficiary can be listed on multiple family petitions. Second, you should prioritize whichever category is fastest when it becomes available. Third, sibling petitions in the F4 category are typically very slow, whereas parent-based petitions often move faster. Fourth, naturalization can unlock faster options. Finally, protect your priority dates and maintain thorough documentation. Before we close, let's include an important disclaimer. This content provides general educational information and is not legal advice. Immigration policies and processing times change, and individual circumstances can significantly affect outcomes. Therefore, you should consult a qualified immigration attorney to obtain advice tailored to your specific situation. With that in mind, let's summarize. In summary, a single beneficiary can have multiple family-based petitions, which creates options rather than speeding up processing. Use petition stacking to position yourself across categories, and then proceed on whichever category becomes current first. Keep all documents to protect earlier priority dates. Finally, if feasible, naturalization can dramatically improve eligibility and timelines. Now, let's wrap up. Thank you for joining us. If this video helped clarify how multiple family petitions can maximize your immigration chances, please like the video, share it with someone who needs it, and subscribe for more practical guides. Finally, share your questions and experiences in the comments. We look forward to hearing your story.